The judge, a pleasant man in a sharp bow tie, leaned forward. His friendly demeanor evaporated in an instant, replaced by a cold, hard focus. He looked past me, his eyes locked on the man representing the multi-trillion-dollar corporation standing in his courtroom. His voice, now devoid of any warmth, cut through the silence. "Apple," he said, letting the name hang in the air for a moment, "does not decide what you can or cannot do in my courtroom." This was my third time suing Apple, all because they wouldn't fix my phone. They thought they were untouchable. They thought I would give up. They didn't realize they weren't just dealing with a frustrated customer. They were dealing with an ex-employee who knew exactly where they kept their money, and I was about to make them pay. Literally. If you have ever felt completely powerless against a giant corporation, if you've ever been made to feel like just a number, then you are in the right place. Hit that subscribe button and turn on notifications, because this is a story about how one person, armed with nothing but principle and a little inside knowledge, can hold even the biggest giant accountable. Like this video, and let's dive into how a simple repair request ended with me legally seizing Apple's cash. It all started about a year and a half ago. Like millions of people, my life ran on Apple products. My MacBook was my workhorse, my iPhone my connection to the world. And as technology is prone to do, both of them started having issues at the same time. The screen on my MacBook was glitching, and my iPhone's battery life had fallen off a cliff. Annoying, but not the end of the world. I had Apple Care Plus, their premium warranty service that I dutifully paid for every month. This should be simple, I thought. I'll just schedule a Genius Bar appointment. But if you've dealt with Apple support recently, you know the word simple left their vocabulary a long time ago. It used to be easy. A few clicks on the support site, and you had your slot. But now it's a fortress. They've erected a digital labyrinth designed to frustrate you into giving up. You're forced through endless troubleshooting articles you've already read. You're funneled into chats with bots that offer useless advice, all in a calculated effort to reduce the number of people who actually make it to a physical store. It's a cynical strategy, I assume, masterminded by some executive, probably Angela Arendt at the time, who figured it was cheaper to lose a few customers to frustration than to hire more technicians. After navigating this digital minefield, after clicking through pop-ups and confirming 10 times that yes, I had already tried turning it off and on again, I finally reached the final gate, the appointment scheduler. A wave of relief washed over me. And then I saw it, a prompt. For your security, you must change your Apple ID password. It has been more than 90 days since your last change. My blood ran cold. Not this. Not again. This was probably the 10th time I'd been forced to change my password for this account. It wasn't because of a security breach. It was just an arbitrary, mandatory 90-day expiration. I could still use my ID to buy apps, to access my iCloud, to spend money without a single issue. But the moment I needed something from them, the service I was already paying for, this ridiculous, unnecessary wall went up. In the past, I had grumbled and complied. I'd sighed, cursed under my breath, and gone through the reset process just to get my appointment. But this time was different. A switch flipped inside me. It was the accumulation of all the little frustration, the maze-like website, the feeling of being actively discouraged from seeking help, and now this final pointless, insulting hoop. It wasn't a security measure. It was a barrier to service. It was a power play, and I had had enough. My jaw tightened. My fingers, which had been poised to type a new password, instead moved to open a new tab. I wasn't going to play their game anymore. I navigated to the Better Business Bureau website. I was done being a compliant customer. It was time to be a problem. I filed a detailed complaint, explaining the situation calmly and clearly. I wasn't asking for the world, I was just asking for the service I was contractually entitled to, without having to perform arbitrary security rituals that had nothing to do with my device's hardware. A week later, Apple's response arrived. It was a masterpiece of corporate non-engagement. A cold, sterile form letter that reeked of being copied and pasted 1,000 times before. It said, and I quote, that changing my password was in my best interests for security reasons, and that they wouldn't be making any exceptions. My best interests? They had no idea what my best interests were. My best interest was getting my expensive, broken devices fixed by the company I paid to fix them. I responded again, this time escalating my language. I pointed out that this policy was completely incongruent with the Apple Credo, the sacred list of customer service principles that every single employee, including me back when I worked there, is trained to uphold. I was calling them out on their own hypocrisy. Their second response was even more insulting than the first. It was just one sentence. One single, dismissive, infuriating sentence. Apple considers this matter closed. This matter is closed. It's corporate speak for go away. It's the professional equivalent of putting your fingers in your ears and humming loudly. It's a message that says, you are small, we are big, and you are not worth another second of our time. The BBB, having no real power, closed the case shortly after. I sat there, staring at the screen, a hot, quiet anger simmering in my chest. They thought they had won. They thought I would just slink away. Another defeated customer. But as they were closing their case, I was just beginning to build mine. I remembered my AppleCare policy. I hadn't just paid for it. I had read it. I pulled up the terms and conditions. The fine print they count on you never reading. I scrolled through, line by line, my eyes scanning for the loophole they thought they had. I went through every exclusion: accidental damage, liquid damage, unauthorized modifications. I searched for any clause, any sentence that said Apple could refuse service based on an arbitrary account security requirement that wasn't even being enforced on the commerce side of their business. And I found it. Or rather, I found a lack of it. It wasn't there. There was absolutely nothing in the contract I had agreed to, the contract they had written, that gave them the right to deny me service for this reason. Their refusal wasn't just bad customer service. It was a breach of contract. A slow smile spread across my face. They had closed the matter.
Fine.
I would reopen it. Not in the court of public opinion, but in an actual court of law. I went down to the local courthouse, paid the $60 filing fee, and filed a suit in small claims court for the full replacement value of both my MacBook and my iPhone. If they wouldn't fix them as per our contract, then they could buy me new ones. The court date arrived a few weeks later. I put on my best suit. I believe in showing respect for the court, and I wanted to present myself as a serious, credible plaintiff. I walked into the courtroom, my heart pounding, a steady, determined rhythm. When my case was called, I walked to the plaintiff's podium, my documents neatly arranged. Then the bailiff called for the defendant, representing Apple Incorporated. I watched the defendant's podium, expecting to see a sharp, intimidating corporate lawyer in a $1,000 suit. But the person who walked up was familiar. He was wearing a t-shirt and jeans. My eyes widened in disbelief. It was the manager from the Apple store I used to work at, a store that was in the same county. Yes, but was a good 45-minute drive away, while there was another Apple store literally a mile from the courthouse. I immediately knew what had happened. Apple's corporate machine hadn't even bothered to read the details of my complaint. They saw my name, did a lookup in their employee database, saw I used to work at that specific store, and just assumed this was some kind of petty employment dispute. So they sent the store manager, completely unprepared, to handle it. The sheer incompetence was staggering. The judge, a stern-looking man, gestured to me. "Mr. Plaintiff, please explain to the court why you are suing Apple." I took a deep breath and, in about 60 seconds, laid out my case. I explained that I was a paying AppleCare customer, that my devices were broken, and that Apple was erecting an extra-contractual, unnecessary blockade to service. Therefore, since they were in breach of our agreement, I was suing for the replacement value of the products they refused to service. It was clean, concise, and based entirely on the contract. The judge nodded, then turned his gaze to the store manager. But before he asked for Apple's side, he asked a simple, devastating question. "Sir, are you a lawyer?" The manager shifted on his feet. No, Your Honor." The judge's expression didn't change. Then you should be aware, he said, his tone flat and educational, that in this state, a corporation cannot be represented in court by a line manager. You must be a chief executive, a registered agent, or a licensed attorney. You do not have the standing to represent Apple in this matter. The manager's face went pale. He was completely out of his depth. He stammered. I understand, Your Honor, but look, I'm happy to set up a Genius Bar appointment for him. Right here, right now, whatever time is convenient. We can get this all sorted out. The judge looked at me. He deemed the offer reasonable. After all, getting the devices fixed was the original goal. We agreed on a time for me to come into my old store. And the judge continued the case for 2 weeks, just in case things didn't work out. I walked out of the courtroom feeling a profound sense of vindication. I had forced their hand. The appointment went perfectly. The technician was great, resolved all my issues, and I was in and out. But then something even better happened. I got an email from a senior Apple technician, someone high up the chain who had clearly been alerted to the lawsuit. He apologized for the issue and informed me that he had personally placed a permanent override on the password expiration requirement for my Apple ID. I would never have to change it again. It was a total victory on the service front. But there was still the matter of the $60. That was the cost I had incurred because they had forced me to sue them just to get them to honor their own contract. The principle of it gnawed at me. I shouldn't be out of pocket because of their arrogance. So, 2 weeks later, I was back in court for the continued date. I was back in my suit, and to my surprise, the same manager showed up again. This time, we had a different judge. The docket was packed, and this judge was a whirlwind, a man on a mission to get through his cases as quickly as possible. He was slashing through them. No nonsense. No time for games. Our case was called. I stood and explained to the judge that the primary issue with the devices had been resolved. I was no longer seeking the replacement value. However, I stated that I should not have had to file a lawsuit and spend $60 to get the treatment I was already paying for. Therefore, I was now asking the court to award me my $60 in court fees. The judge nodded, then turned to the manager. "And you, sir, are you a lawyer?" "No, Your Honor," the manager said. The judge gave him the exact same spiel the first judge had. "You can't represent a corporation in my court." But this time, the manager, perhaps feeling emboldened or pressured, tried to argue. "Your Honor, I still believe the court fees shouldn't be Apple's responsibility because we offered to fix the devices." The judge, clearly pressed for time and having no patience for this, cut him off. He turned to me. "Look," he said, his voice sharp with impatience. "I assume you don't want to have to come back here a third time for them to get a lawyer, right?" I said, "No, Your Honor," thinking he was about to award me the full $60 to end it. But he didn't. He said, "Okay, then you'll just split it, so we don't have to waste any more time on this. $30 to the plaintiff. Next case." And he banged the gavel. I was stunned. I just stood there, speechless. Split it? According to my state's laws, which I had researched, a prevailing party, which I clearly was, since a judgment was entered in my favor, is entitled to all of their court costs. The judge, in his hurry, had just ignored the law to clear his docket. As I walked out, the sting of injustice was back, sharper than before. It wasn't about the $30, it was about the fact that Apple's continued disrespect for the legal process had been rewarded. But they had made one small, crucial error. After the first hearing, an Apple paralegal had emailed me to confirm the details of the Genius Bar appointment. I now had a direct contact within their legal department. I went home and composed an email. I was polite, professional, and firm. I explained the situation. I cited the specific state law regarding court costs for a prevailing party, and I pointed out that the judge, in his haste, had made a clear legal error. I then laid out their two options. Option A, they could acknowledge this, cut me a check for the full $60, and we could all move on. Option B, I could file an appeal. The filing fee for an appeal was an additional. When I inevitably won the appeal, because the law was black and white, they would be on the hook, not just for the original $60, but for the $125 appeal fee as well. They would owe me. I was appealing to their common sense. Pay me $60 now, or pay me $85 later. The choice was obvious. Or so I thought. Their response was dripping with the same corporate arrogance that started this whole mess. The paralegal wrote back that Apple would follow the court's judgment only, and that a check for $30 was in the mail. They were calling my bluff. They were so blinded by their own self-importance that they couldn't fathom me, one single person, actually going through with an appeal over such a small amount. They assumed I would just give up. They assumed wrong. I took their letter, drove back to the courthouse, and I filed the appeal. This time, it wasn't small claims court. An appeal from small claims goes to the next level up, the circuit court. This was, as they say, big boy court. This was a place for real lawyers, real stakes, and absolutely no bullshitting. The day of the appeal hearing arrived. I put on my suit for the third time. I walked into the grand, intimidating circuit courtroom, and I swear, you cannot make this stuff up, walking towards the defendant's podium. For the third time was the very same store manager. I almost laughed out loud. 3 times they had been told. 3 times they had ignored the court. Their arrogance was truly limitless. The judge this time was a completely different character. A bouncy, cheerful man in a vibrant bow tie. He seemed to be having a wonderful morning, greeting everyone with a pleasant smile. He called our case. I stood and presented my argument simply. I explained that I was the prevailing party in the lower court, that state law dictated I be awarded my full court costs, and that the judge had erred in splitting them. The judge in the bow tie listened intently, nodded, and then turned to the manager. And for the third time, the fateful question was asked. "Sir, are you an attorney?" The manager, looking more nervous than ever, said, "No, Your Honor, but I have a letter." He held up a piece of paper. "It's from Apple's chief legal counsel. It says that it's okay with them, that I represent the company today." The judge's bouncy, pleasant demeanor vanished, as if a switch had been flipped. The smile on his face didn't just disappear, it was replaced by a look of profound, icy anger. He leaned forward, his voice suddenly sharp and dangerous. "Sir, Apple does not decide what you can or cannot do in my courtroom. The law decides, and the law says you need an attorney. We will likely need to continue this case to allow you time to get one." He then turned to me. "Mr. Plaintiff, do you object to a continuance for the defendant to get an attorney?" This was the moment. The culmination of all their disrespect, their dismissiveness, their utter contempt for the process. I looked the judge in the eye. "Yes, I do, Your Honor. I object strenuously." The judge raised an eyebrow. "On what grounds?" "On the grounds that this is the third time Apple has been told they need to have a lawyer present in court," I said, my voice ringing with righteous indignation. "They have shown a consistent and flagrant disrespect for this court and its procedures by repeatedly sending the same layman to argue on their behalf. They have had ample opportunity to correct this, and they have chosen not to." The judge stared at me for a long moment. Then, his face broke into a wide, sarcastic grin. He turned back to the terrified manager, throwing his hands up in a theatrical, "What can you do?" gesture. "Sorry," he chirped, the fake pleasantness dripping from the word. His objection is sustained. He turned back to his paperwork, his pen scratching loudly in the silent room. "Judgment is entered in favor of the plaintiff. Apple will pay the original $60 in court costs, plus the $125 fee for this appeal. Total judgment." He banged his gavel. It was over. I had won. But of course, with Apple, it was never truly over. The judgment stipulated that they had 30 days to pay. 30 days came and went. No check arrived. My satisfaction began to curdle back into frustration. I emailed the paralegal again. The response was yet another exercise in corporate delusion. "We are still looking into our options," she wrote. Options? What options? Their 30-day window to appeal to the state Supreme Court, an appeal they would have been laughed out of, had already closed. They were still acting as if the rules didn't apply to them. They thought they could just not. And that's when they seemed to forget the most important detail of all. The detail that had been right there in their files from the very beginning. I used to work for them. And when you work for a company, you get paychecks. And those paychecks are drafted from a bank. A slow, wicked grin spread across my face. I dug through my old records and found an old ACH transaction from my payroll days. I called my credit union. Can you tell me which bank this transaction was drafted from? A few keystrokes later, the representative gave me the answer. That's from a Wachovia account, sir. Wachovia. Now Wells Fargo. It didn't matter. I had them. I went back to the courthouse one last time. I didn't need to sue them again. I already had a judgment. I just needed to collect. I filed for a writ of garnishment against Apple Incorporated via their accounts at Wachovia Bank. Normally you have to go through a discovery process to find a defendant's assets. But I gotta skip that part. I already knew where they kept at least $185 of their money. The court processed the paperwork and sent the order directly to the bank. A few days later, a check arrived in my mail. It wasn't from Apple. It was from Wachovia. They had been legally compelled to dip into Apple's corporate account and pay me what I was owed. I held that check in my hands. A simple piece of paper representing the end of a 1.5-year-long battle. They had tried to ignore me, to dismiss me, to outspend me, and to outweight me. But in the end, I didn't just get my devices fixed. I got my password problem solved. Forever. I got my money back. And I got the profound, quiet satisfaction of knowing that I had used their own system, their own contracts, and their own money to hold them accountable when they believed they were above it all. In the end, it was never about the $60 or even the $89. It was about a simple principle. When you make a promise to your customers, you keep it. And if you don't, you can't be surprised when one of them decides to read the fine print and make you. It's amazing what you can accomplish when a company underestimates you. What's the most satisfying time you've ever seen a massive corporation get put in its place? Let me know your stories in the comments below. And if you enjoyed watching justice get served, don't forget to hit that like button, subscribe for more stories of righteous revenge, and share this video with someone who needs a reminder that even giants can fall. Thanks for watching.